Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Rivers v. Guerrero. In this case, the court considered this issue. Does 28 U.S.C. section 2244b(2) apply to all second habeas petitions, or only specific types of second petitions? The case was decided on June 12, 2025. The Supreme Court held that when a district court enters judgment on a first federal habeas petition, any subsequent habeas filing qualifies as a second or successive application subject to the strict requirements of Section 2244b, regardless of whether the first petition is pending on appeal. Justice Ketanji Brown Jackson authored the unanimous opinion of the court. The Antiterrorism and Effective Death Penalty Act, AEDPA, establishes significant procedural barriers for second or successive habeas applications. These restrictions prohibit relitigating previously denied claims and permit new claims only when they rely on new retroactive constitutional law or present previously undiscoverable facts establishing innocence. Additionally, petitioners cannot file successive applications directly with the district court but must first obtain authorization from the Court of Appeals after making a prima facie showing that their petition satisfies one of Section 2244b(2)'s narrow exceptions. The phrase second or successive application constitutes a term of art that applies to filings seeking adjudication of federal claims on the merits, not merely to all filings made second in time. The entry of final judgment, not the pendency of appeal, marks the dividing line between first and second or successive habeas applications. While amended petitions filed before judgment do not trigger Section 2244b, and Rule 59e motions represent a limited continuation of the original proceeding that merges into the final judgment, new habeas filings submitted after judgment constitute second or successive applications even during appeal. This rule advances AEDPA's purposes of conserving judicial resources, reducing piecemeal litigation, and lending finality to state court judgments. Allowing petitioners to file unlimited new applications during appellate review would encourage inefficiency and make it difficult to produce a single final judgment for appeal. Historical habeas doctrine before AEDPA provides no clear guidance, as courts inconsistently treated new filings during pending appeals. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Jackson delivered the opinion of the court. Incarcerated individuals who seek to challenge their imprisonment through a federal habeas petition are generally afforded one opportunity to do so. Before a federal court can address a petitioner's second or successive federal habeas filing on the merits, the incarcerated filer must clear strict procedural hurdles that the Antiterrorism and Effective Death Penalty Act of 1996, AEDPA, erects. This case presents the question of how to classify a second-in-time habeas filing when the judgment denying the first application is under review on appeal. Does that second habeas-related submission qualify as a second or successive application, thereby triggering Section 2244b's stringent gatekeeping requirements? We hold that, in general, once the district court has entered its judgment with respect to the first habeas petition, a second-in-time application qualifies as second or successive and is thus properly subject to the requirements of Section 2244b. In 2012, a Texas state court jury convicted petitioner Danny Rivers of continuous sexual abuse of a child, 2 forms of indecency with a child, and possession of child pornography. Rivers unsuccessfully sought direct appeal and state habeas relief. In August 2017, Rivers filed his first federal habeas petition under 28 U.S.C. section 2254, a statute that permits a federal court to evaluate a state prisoner's claim that he is in custody in violation of the Constitution or laws or treaties of the United States. In that habeas petition, Rivers asserted, inter alia, claims of prosecutorial misconduct, ineffective assistance of trial and appellate counsel, and due process and equal protection violations. The district court denied Rivers' habeas petition, issuing its judgment in September 2018. Rivers then invoked the procedure that AEDPA prescribes for seeking to challenge a Section 2254 habeas denial in the Court of Appeals. He asked the Fifth Circuit to give him what is known as a certificate of appealability. A Fifth Circuit judge granted Rivers' request in July 2020, but only as to his claim for ineffective assistance of counsel. While his appeal was pending, Rivers gained access to his own client file, which had been in his trial counsel's possession. The file contained a state investigator's report that discussed 2 computer documents Rivers believed were related to his convictions. One document was labeled of interest, while the other was specifically described as not child porn. Rivers promptly requested to supplement the Fifth Circuit's case record with this purportedly exculpatory information, but the Fifth Circuit denied that request. Rivers then asked the appellate panel to either stay the appeal or remand the case to the district court to allow him to present this new evidence to the lower court in the first instance. The Fifth Circuit rejected the stay or remand request as well and, thereafter, affirmed the district court's denial of Rivers' Section 2254 petition on the merits. Notably for present purposes, after the Fifth Circuit denied Rivers' request to supplement the record, Rivers filed another Section 2254 petition with the district court. This petition included the newly obtained state investigator's report and raised claims for relief related to that evidence. A magistrate judge recommended that this second-in-time habeas petition be classified as a second or successive habeas application for Section 2244B purposes. Rivers objected, arguing that his second Section 2254 filing should not be construed as a new habeas application. Rather, Rivers asserted, the new filing should be treated as an amendment to his initial habeas petition, because the judgment related to that first petition was still on appeal. The district court rejected Rivers's argument. It concluded that the second-in-time filing was a second or successive habeas petition subject to Section 2244B, 2, and transferred the filing to the Fifth Circuit for a determination whether Section 2244B, 2's gatekeeping requirements for second or successive habeas petitions had been satisfied. Rivers then appealed the district court's transfer order, again insisting that his filing was not a second or successive habeas petition, as opposed to a motion to amend, because his first-in-time petition was still pending on appeal. The Fifth Circuit affirmed. In its view, the timing of Rivers' second-in-time petition did not permit him to circumvent the requirements for filing successive petitions under Section 2244. The panel reasoned that the district court could have treated the second-in-time filing as a request to amend under Federal Rule of Civil Procedure 15, if the judgment relating to Rivers' first petition had been vacated on appeal, and the case reopened in the district court. But because the judgment as to the first petition had not been so vacated, Rivers' second-in-time habeas petition was a second or successive petition that was subject to the district court's transfer order for lack of jurisdiction absent authorization to file. Habeas petitioners are generally entitled to one fair opportunity to litigate the merits of their post-conviction claims in federal court. When a person seeks to bring a subsequent federal habeas challenge to his detention, the road gets rockier. AEDPA contains several significant procedural barriers that strictly limit a court's ability to hear claims presented in any second or successive habeas corpus application. Several of those barriers are relevant to the issue presented in this case. First, Section 2244 prohibits habeas applicants from filing a subsequent petition that relitigates the merits of previously denied claims. Second, even if the subsequent petition presents a new claim, the second-in-time application can only proceed if it falls within one of two narrow categories. The claim must rely on a new and retroactive rule of constitutional law or allege previously undiscoverable facts that would establish the petitioner's innocence. Additionally, a petitioner cannot bring a second or successive habeas application directly to the district court. Instead, he must first go to the Court of Appeals and make a prima facie showing that the petition satisfies one of Section 2244B, 2's exceptions, and that court has to grant authorization for the petitioner to proceed in district court. And then, even when such leave is granted, the district court must independently confirm that the petition satisfies the requirements of Section 2244B, 2. These rules apply to second-in-time habeas filings even if the filing is not styled as a Section 2254 habeas application by the filer, so long as the document is a Section 2254 petition in substance. For example, a self-styled motion that seeks to add a new ground for relief or attacks the federal court's previous resolution of a claim on the merits can be construed as a second or successive petition, and forced to face the gauntlet of Section 2244B, no matter how it is labeled. Respondent presents two arguments for why we lack jurisdiction over today's dispute about how Rivers' second-in-time habeas filing should be characterized. First, that Rivers lacks standing because his injury is not redressable, and second, that the court lacks habeas jurisdiction because Rivers' child pornography sentence has expired. For his part, Rivers makes two alternative arguments about the merits. He maintains that the second-in-time habeas petition does not trigger the second or successive requirements of Section 2244B, because his appeal of the first petition was pending when he filed the second one. Alternatively, he argues that his second-in-time filing should be construed as a motion to amend, and so construed, does not qualify as an application to which Section 2244B's requirements apply. We begin our analysis by quickly disposing of Respondent's contention that we lack jurisdiction. Respondent first insists that Rivers lacks standing because the Fifth Circuit has now affirmed the district court's judgment denying the initial habeas petition on the merits, and this court lacks the authority to reopen that judgment in this separate litigation. But a favorable decision from this court would redress Rivers' alleged injury, namely, that the district court inappropriately transferred his second-in-time habeas application to the Fifth Circuit for review under Section 2244B. Rivers therefore has appellate standing with respect to that legal claim. Respondent is also mistaken regarding the contention that the court lacks habeas jurisdiction, because Rivers is no longer in custody on the child pornography conviction that the second habeas filing challenges. The record establishes that the newly discovered evidence Rivers wants the federal courts to consider implicates the sexual abuse sentences for which Rivers remains incarcerated too. Thus, we retain habeas jurisdiction to review his claims. Turning to the parties' merits arguments concerning Rivers' second-in-time habeas filing, we note, to start, that the phrase second or successive application as it appears in Section 2244b, 2, is a term of art, that is, it does not necessarily refer to all habeas filings made second or successively in time, following an initial application. Instead, the second or successive moniker applies only to claims that have been presented in subsequently filed applications. A claim, as that term is used in Section 2244b, is an asserted federal basis for relief from the judgment of conviction, and an application is a filing that seeks an adjudication of one of those claims on the merits. Rivers acknowledges that his second-in-time filing raised several new claims that he had not presented previously to the district court. Still, in his petition for certiorari, and, to a lesser extent, his merits brief, Rivers argues that this filing did not qualify as a second or successive application triggering Section 2244b, because it was submitted during the pendency of his appeal of the judgment related to his first habeas petition. We do not agree with that proposition. Our case law establishes instead that whether a filing qualifies as a second or successive application generally turns on the existence of a final judgment with respect to the first petition, not the status of an appeal. We have noted, for example, that an amended petition, filed after the initial one but before judgment, is not second or successive for Section 2244b purposes precisely because final judgment has not issued. On the other hand, we have determined that a motion for relief from judgment under Federal Rule of Civil Procedure 60b, filed, obviously, after the judgment has issued, counts as a second or successive application if that filing attacks the federal court's previous resolution of the claim on the merits or seeks to add a new ground for relief not addressed by the judgment. Pointing to Bannister, Rivers insists that this court has already rejected a moment of judgment rule for distinguishing between second-in-time filings that qualify as second or successive applications and those that do not, but our ruling in Bannister related to a materially different filing submitted in a materially different context. There, the court considered whether a motion to alter or amend a judgment under Federal Rule of Civil Procedure 59EI.e, a motion filed within 28 days that seeks to correct an error in the district court's judgment prior to an appeal, should be construed as a second or successive filing under Section 2244b. To be sure, the respondent in that case had urged this court to hold that entry of final judgment is the dividing line between a first and second application, as Rivers notes. But Rule 59e motions present a unique variant to the otherwise generally applicable rule that entry of final judgment separates first from second or successive habeas filings. Specifically, unlike a Rule 60b motion for relief from judgment, which seeks to challenge an extant judgment, a successful Rule 59e motion merely suspends finality of the original judgment so that the district court can fix any mistakes and thereby perfect its judgment before a possible appeal. A Rule 59e motion is a limited continuation of the original proceeding, indeed, a part of producing the final judgment granting or denying habeas relief. As a result, disposition on a Rule 59e motion merges into the final judgment of the initial habeas filing. In other words, Rule 59e motions are attendant on the initial habeas application itself and help produce a single final judgment for appeal. Thus, they are not themselves properly considered to be second or successive filings under AEDPA. When properly understood, then, our decision in Bannister actually supports the rule that Rivers resists. Rivers also maintains that it undermines the purposes of AEDPA, and diverges from historical habeas doctrine and practice, to conclude that second-in-time applications filed during the pendency of an appeal trigger Section 2244b. But purpose and history do not push us in the direction of adopting Rivers' preferred interpretation either. As we have said before, the point of Section 2244b's gatekeeping restrictions is to conserve judicial resources, reduce piecemeal litigation, and lend finality to state court judgments within a reasonable time. Rivers argues that his interpretation advances these aims by, for example, steering new claims to district courts, which have the tools and experience that appellate courts lack to terminate suits and thereby hasten finality. But the reality is quite the opposite. If the second or successive line is drawn at the end of the appellate review period, a petitioner could file any number of new applications raising new claims during the pendency of appeal or certiorari review, thereby prolonging the case seemingly indefinitely. So, as a practical matter and in the mine run case, Rivers' theory would promote inefficiency by encouraging piecemeal litigation, and would thus make it substantially more difficult to produce a single final judgment for appeal. Rivers tries to bolster his congressional intent-related arguments by pointing to other post-conviction provisions that pin finality to the end of appellate review, not to the entry of judgment. We note, however, that these provisions are buoyed by different animating purposes. The one-year deadline for filing a Section 2254 petition, for example, promotes exhaustion of claims and respects state court processes, whereas AEDPA's second or successive restrictions constitute a modified res judicata rule that balances finality and error correction. It is thus hardly strange that rules governing exhaustion and the statute of limitations for purposes of bringing an initial application differ from those governing a successive application. With AEDPA's second or successive bar, Congress chose to promote finality by requiring authorization from the Court of Appeals to file successive petitions. The question before us today is merely when that requirement kicks in. Rivers' appeal to historical habeas doctrine fares no better because, prior to AEDPA, there was no clear or consistent practice regarding how new habeas-related filings were treated during the pendency of an appeal. Some courts would consider new habeas filings on the merits, and deny them, when the first-in-time habeas petition was under appellate review. But others would dismiss such filings without reaching the merits, on the ground that they were second or successive petitions not subject to review. It is difficult to know what to make of these inconsistent practices, especially when Rivers fails to point to any case in which a court actually granted habeas relief on a subsequent petition while the first was on appeal. The historical picture is thus far too murky to be dispositive. As such, Rivers' history and policy arguments do not move the needle in our analysis. In short, we reject Rivers' focus on the timing of his successive filing relative to the pendency of his appeal, and we conclude instead that it is the final judgment related to the initial habeas filing that matters. Once the judgment has been entered with respect to the initial habeas petition, a second-in-time filing that makes new habeas claims generally qualifies as a second or successive petition for Section 2244B purposes. Rivers' petition for certiorari posited the question we've answered above, but Rivers' merits briefing pivots to articulate an additional theory, in the alternative, that second-in-time filings that request amendment of the initial habeas petition under Rule 15 of the Federal Rules of Civil Procedure do not, by their nature, qualify as second or successive filings under Section 2244B. We decline to address this argument today for two reasons. First, Rivers failed to present this argument in his petition for certiorari or to the courts below. This new theory for why his successive filing does not trigger Section 2244B does not operate on the timing of the filing, i.e., whether, when an appeal is pending, the filing is second or successive, but, rather, on its nature, i.e., whether, when submitted under Rule 15, the filing counts as an application at all. Rivers did not cite Section 2242, the source of authority upon which he relies for this alternative argument, until his opening merits brief in this court. We have often said that we are a court of review, not a first view. Second, and in any event, we note that the factual predicate necessary for Rivers' Rule 15 argument to help him in this case is lacking. The district court could not have granted Rivers' Rule 15 motion to amend, assuming, arguendo, that we treat his second-in-time filing as such, while his habeas claims were being considered on appeal, since jurisdiction had shifted to the Court of Appeals. Recognizing this, Rivers asserts that the district court could have issued an indicative ruling on this motion under Rule 62.1, which, in turn, might have persuaded the Fifth Circuit to remand the case to the district court for consideration of the amendment. But there is one more missing piece, and it is crucial. Rivers never asked the district court in this case for such an indicative ruling, nor does he argue that the district court abused its discretion by failing to issue one sua sponte. Meanwhile, the Fifth Circuit considered, and denied, the actual remand motion that Rivers filed with that court. He asked the circuit to send the matter back to the district court for consideration of the newly discovered evidence, and we now lack jurisdiction to review its refusal to do so. Thus, even if Rivers' filing in the district court could have been construed as a Rule 15 motion to amend, the district court was powerless to grant it while his case was on appeal, and the Fifth Circuit had no proclivity to remand the matter to the district court in any event. This means that Rivers' alternative theory is of no use to him, and, as such, we decline to address it. A second-in-time Section 2254 petition generally qualifies as a second or successive application, triggering the requirements of Section 2244B, when an earlier filed petition has been decided on the merits and a judgment exists. Because the Fifth Circuit correctly applied this straightforward rule, we affirm. It is so ordered. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.